All right, okay, so we have reached our cap for participants as well. So we'll be starting. I'll begin by introducing our really special panel. We have with us Mr. Sridhar Radhakrishnan. We have Dr. Biju Kumar. We have PZ Thomas sir with us. And we also have Advocate Harish Vasudevan sir. Unfortunately, Tara ma'am got caught up and she will try her best to join in. But until then, we will carry on with our discussion. I would like to hand over the panel to Dr. Biju Kumar for now. So over to you.
Yeah, good evening. Can you hear?
Yes, sir, we can hear you.
Yeah. Primarily, I thought it was Harish to begin the discussion because this involved a lot of legal implications and things like that. But I'll just start the discussion by expressing my own views in this regard. And see, when you travel from 2006 to 2020, you will see a lot of dilutions happening. So I speak on some specific issues, and one is regarding the dilution which is there, particularly the dilutions which is there in the system. And before I start, I will also tell you what were the issues in the earlier EIA also. See, now all the discussions actually are centered on the issue of the current draft. But I would also like to tell you that even the existing EIA notification has its own issues. And the first issue, which I will tell you, is that throughout the world, see, we as a country follow the EIA notification and draft the EIA notification based on a series of international agreement which we are part of, including the CBD, including the climate change agreement, etc., where the EIA is very much specified. And that in that case also, the problem is that the proponent, the implementing agency for the EIA is actually finally decided by the proponent itself. So there starts all the issues. Suppose I have a project to implement, I will specify the agency to for the environmental monitoring, and that is one thing. And then second issue, even in the current EIA, is that the major documents are not consulted. And I know many of the EIA, I have studied many of the EIA at the national level, including with the larger major projects. And we can see that majority of the published material are not consulted. That means even there is no screening for, or the baseline for the amount of data that has to be screened as part of the knowledge consolidation. And that never happens. You just go to a particular area, do some survey, and then finally arrive at your own conclusion. And we have a set models, especially for the larger implementing agencies. We have a set model, and then you follow that. And then if you have very good in statistical interpretation and modeling, and you can create a beautiful report. Okay, so that is one part. That means the knowledge base and the knowledge bank is not considered. That is one issue. And second issue is the biodiversity component of that. The biodiversity component is not specifically taken into account in many of the things, especially the larger databases like IUCN, where even in many of the critical ecosystems in India, there is no database at all. So that means there is a knowledge gap, and that knowledge gap is taken advantage by many of the EIA agencies, and that is a second issue. So these are the issues with the current system. And second, another issue, even at present, is that the post-project assessment, the post-project management plan. Many of the larger environmental projects are cleared based on the assumption that the company or the proponent will implement all the management plans towards the end. And that also never happens. So these are the issues with the current plan also. And then Mr. Harish will also, I am sure, that speak about the inability of the National Green Tribunal as far as implementation of the larger projects are concerned. And that's an entirely different topic of discussion, which I am not interested to go into because it's not my field of activity. Okay. And now the issue is that excluded projects. So dilution happens in the case. So that's the first point which I wanted to discuss today. And one is actually the dilution process. The dilution happens primarily with regard to the renewable energy project, solar, particularly the solar thermal projects. I'll tell you one example of a solar project, and which is supposed to be, of course, the government has internationally there is actually a thrust for renewable energy. Fine, but that doesn't mean that the larger renewable energy projects will not have any the environmental repercussions, and this is an issue. For example, if you look at some of the solar project which is already sanctioned, and for example, you look at the solar project which is already installed at the Gujarat with the help of the World Bank. And if you go through the EIA report, you clearly understand that the report very clearly says that when a larger solar park is established in a particular area, it will have severe implications on the drainage pattern in that area. That means there is a serious issue with regard to the drainage pattern as well as the environmental issues in that area. So you have to have a clearance on that. So that means even a larger project which is actually excluded will have some environmental impact issues here. So that's one of the issue. And that means which we have to actually suggest in the as a modification is that whatever may be the extent of project, all the projects should have an environmental impact assessment, and the implication should be actually studied thoroughly before sanctioning a project. So even if it is an excluded project, it should have an environmental clearance, and if there is a public opinion against that, that must be seriously studied before going for any kind of clearance. That's my first argument. And the second argument, definitely everybody will speak on the public participation. Public participation is actually a rule throughout the world. If you look at any environmental impact environmental law in any part of the world, public participation is one of the major component. And here there is a dilution. I am sure that everybody will be speaking on that, and then I am not going into the details of that. But here one problem which I wanted to highlight is that in the category B2, and where there is a blanket permission which is given, and which of course is not possible in any kind of public participation, and reducing the dates from 30 to 10 is actually a means to kill the entire spirit of the law, and that is what I wanted to tell you there. And then there should be in the case of there's a constitutional issue. For example, the draft notification says that don't disclose the criteria for exemption. So if if the government is not in a position to disclose the criteria why a project is given clearance, and that again is against the Right to Information Act and all the succeeding acts connected with that. This is one of the other issues. And then another point which I wanted to tell you is that the deviation from all the international agreements that we have. For example, the principle of sustainable development strongly implies the precautionary principle as well as the polluter pay principle, which is not at all adapted by the government in any of the environmental clearances process. So this is another thing which I wanted to tell you. And now definitely that in the next Independence Day, the government will come out with another proposal to the ban plastic, which is again which is a repetition of the last time the announcement, which never happened, which never materialized, primarily because of the pressure created by the industries in connection with that. Unless and if you just wanted to get a popularity, then you will get. And all these things are done primarily in the name of for safeguarding the interests of the industries. So this is happening in this case also, just like the already announced plastic ban, the single-use plastic ban, and nothing materialized. And this is the same thing, because we are not actually going in alignment with the international agreements which we are part of. Okay, and then even within the system, the public hearing and public participation, public consultation is possible. And that is exemplified by Mr. Jairam Ramesh when he was a minister in the case of genetically modified organism. That kind of a consultation was done, and that is primarily the reason why the project got postponed. So that is one thing which is again very clear. And also you have to see the Vedanta mining issue and the case connected with that. And that is very clearly, the court order very clearly says that wherever the project is implemented, you have to first hear the local body, and that is not there in this case. And the local body is the first, or the local self government is the first institution to be here heard in any case of any developmental project, and that is never taken care of. This is another issue. And finally, before I come to the next issue, we should also understand that there is actually an issue with the post facto approval. And post facto approval in the whole process drafted EIA is actually a mess. And also this is done purposefully to give clearance first and then go for the subsequent the procedures. And also the if you go through the draft, there is this is primarily to legitimize the illegal transaction of the industries. And if you go through the draft, then you will understand there is a sentence. If there is a violation, such violations being recurring in nature may come to the notice of the future process of appraisal or monitoring or inspection by the regular authorities. And that means there is again a dilution in the whole process of approval. That means you give the approval first, and then if there is a subsequent complaint, then we have to look into the whole process again. And then suppose, and there is again a very drastic issue there. Suppose a project developer reports a violation, then the environmental management plan, then the penalty is only 1.5 times. And suppose the government find out a problem, and then the compensation is 2 times more. And that means the developer has actually the facility to record a complaint and then get it clarified. So this is again a serious dilution which has happened in the case of the post facto approval. And since I am working with the marine system and the freshwater system, there is another very interesting case in the draft EIA where dredging is legitimized. That means even if a dredging project within the harbor or outside the harbor, within the marine ecosystem, you need a clearance. Fine. But if the dredging is done within an inland water body, now no clearance is required. That means dredging is defined only in the case of a marine system, and the freshwater system is totally left out. That means all the inland navigation projects now need no environmental clearance, especially with regard to dredging. So this kind of a dilution is also there with regard to this project. Okay. And now I'll just tell you some of the basic fundamental constitutional obligation of the government and its violation. And first is actually with regard to the post-EIA management plan. And this is actually a total mess, even in the current environmental impact assessment plan, because there is no monitoring. And once you said that the project proponent declare that the management is done, and that is done in paper, and nothing happens in the field. And you can take a case study. The youngsters here, you can take up any case study. What is the post project management plans, and what is the success percentage, and what is the fate of that after a few years, etc., etc. Okay. And then second is that with regard to data bank, the Environment Ministry has no data bank which is transparent, which is publicly available. And that is again, this happens only with this country, where no data bank is available with regard to wetland, with regard to the forest, with regard to many of the environmental sensitive areas. And another thing is that if you go by the national international policy in the recent past, even if you go for 2020 biodiversity target, or if you look at 2030 sustainable development plans, or the current post 2020 targets, then you will see that the major thrust is given to nature-based solutions. And this current notification has nothing to say with the nature-based solutions, because that is going to be the major strategy. You speak about any international agreement for future, particularly the global green deal or whatever it be. This is not there. This is again a very serious lapse on that. And then a consultancy process, the whole consultancy projects, there should be actually a set of nationally accredited consulting agencies where the data should be available to the public. all the environmental monitoring data and all the subsequent databases should be available to the public, as well as it should be transparent and accountable. And these are the things. Okay. And then public participation in decision making. I'm not speaking about the public consultation process, but public participation in the whole process of decision making. And that element should also be there, because that is not happening in any of the policies, environmental policies, as far as India is concerned. And only the bureaucrats and some elected or selected political representation is there. And this is another thing. Then finally, before concluding, one more sentence about the agencies who are actually struggling to replace the whole draft. The problem again with the environmental NGOs and environmental organizations involved in that there are large number of very good NGOs, and that is the reason why there is actually a nationwide awareness about the draft EIA, thanks to all of them. But majority of the environmental organizations lack a serious focus. So if you are working in no environmental NGO or agency can work on everything under the sun, and there should be actually specialization which should happen in India. So if you are working, if Tanali is working in agriculture, and definitely they should be actually a focal point for answering all the thing in agriculture. And that doesn't mean that they can answer anything. For example, a project in the sea is coming, ocean is coming up, and then they can answer the same thing with the same spirit. So the environmental organization should also make it a point and that they should actually specialize in certain areas rather than speaking anything under the sun and engaging in everything under the sun. And this is again one issue there. And second is actually studying the matter. I'm sure that many of the cases are actually left out and rejected by the court primarily because of lack of evidence. If you say that there is a plant will be destroyed, a fish will be destroyed, and then the court will not actually agree with that. So you should actually have a database, and you should work for a database, and the database should involve the ecologically sensitive areas or the species which are critically endangered and things like that. So the element which is necessary for a court to approve a project should be there. And that is severely lacking with regard to the people who are actually struggling to put the things in order. Okay. And then finally, we all, including the scientists, many of us are not consulted in any of the areas where we have the expertise. Okay, we have some selected, the so-called indexed people who will be answering to many of the environmental issues connected with that, and that should actually should not be the case, because we, along the environmental agencies, the connected the scientists, engineers, and the people, the journalists, we should form a network. And this kind of a network is totally lacking as far as India is concerned. And even if there is a network, they're all highly partial, and they are also form it for a lobbying purpose. And in fact, if you need a kind of public momentum which is happening against this kind of atrocities, like the draft environmental impact assessment report, here we need this kind of a networking. Thank you.
Thank you so much, Biju sir. That was very, very insightful. I think we will keep a time period of 5 minutes for entertaining any sort of questions or doubts or queries from our audience. So if anyone has any sort of question for Biju sir, please go ahead and we'll answer them right now. Okay, so there's a question in the comments. So nowadays we talk about stopping plastic pollution. Why can't we restrict them in the production through pollution acts?
Well, see, the ban comes only with regard to the selling of the single-use plastics now, and that is not, again, a kind of uniform national law is not there. We have a restriction with regard to the thickness of the plastic and not with regard to the production, unfortunately. Okay, so probably when we have a national law, the restriction comes only with the sale of single-use plastics of selected items. At present, this is applicable only with the carry bags and things like that. But unless and until we have the control at the production point, this will not happen. So probably what we have to think, or we have to pressurize is to go for a kind of pollution, the polluter pay principle adopted into the adopted, as well as there is some kind of management in the production cycle as well. So unless that happens, there is no kind of law which can be highly useful. And we unfortunately, what we do is that we only go for we produce more and then we go for a management, and unless and until the upstream management happens, and nothing will materialize, and that is same applicable in the case of plastic gas.
All right, thank you so much, sir. We have Advocate Harish Vasudevan sir with us right now, so I will pass over the panel to him. Sir, would you like to address all of us?
Thank you, Shreya. I'm sorry for being late due to traffic congestion and all, and heavy rainfall in Kochi. Since most of the people who are attending this program are basically aware, having awareness about EIA notification 2020 draft and its problems. As I can point out three dilutions very quickly. That one is total taking away of projects and activities from the EIA regime itself. That is, activities which are covered by 2006 notification is not covered in 2020. And by increasing the threshold limit, many of the activities are included in namesake, but it is not actually covered by 2020 draft notification. And the serious problem, as already mentioned by Dr. Biju, is the post facto clearance process. This actually defeats the whole purpose of EIA notification as such. Nobody is going to apply for environmental clearance or conduct EIA if there is no provision for stopping post facto clearance. If post facto clearance provision is there, no person is going to apply in the beginning. Only after the project is completed, they will apply. Now, what is the intention of the ministry by put forth such kind of a notification? It is evident from the statement of the minister that we are focusing on polluter pays. The cat has come out. That is what I understood. That they are going to permit the polluting as a norm, as a new norm, and they are bringing polluter pays principle instead of precautionary and sustainable development. So this is point number one, which we should focus, and we should think, ask ourselves as to whether we are going to fight against it even after August 11th. Whether we are going to fight against this ministry who is focusing on polluter pays, whatever be the punishment after polluting the air, water, and environment, they are going to focus the polluter pays. The whole EIA is going to focus on the polluter pays. That is very evident from the statement. And we have sorted out a very big list of activities which are dilutions, which are already taken away from this B2 categorization and taking away EIA and public consultation. The days for public consultation notice is very that has been reduced from 13 to 20. We have discussed all these things in general. There are so many videos available in YouTube also regarding that. I am focusing on something else. Now, if we see the amendments in EIA notification for the past 10 years through office memorandums and through notifications, you can see that the Environment Ministry has become a facilitation center for environmental degradation. This I am stating with responsibility that we can prove easily that the Ministry of Environment and Climate Change has now become a facilitation center for environmental degradation. This should be highlighted. The purpose of the ministry is being defeated through the officials and the minister who is sitting there. This is not with respect to this ministry, but to earlier ministers also and earlier ministry also. From last 10 or 15 years, this ministry is diverting from its purpose of the administration. Now, whether it is culpable, whether it is knowingly doing, or whether it is due to some pressure or due to some public demand or something, that we can discuss. When we discussed about the ban of endosulfan, as Sridhar sir know, the then Minister of Agriculture told to the nation that the agriculturists of this country require endosulfan. Nobody is asking for ban. More farmers are asking for continuing endosulfan. So we filed an RTA application asking the ministry as how many farmers have asked not to ban endosulfan. There was only 6 letters in the ministry for opposing endosulfan ban, and there was more than 4,000 letters asking for endosulfan ban. So the ministry was exposed that they are not protecting the interest of the farmers, but they were protecting the interest of some industrialists in the name of general public. Here, there are several judgments of Delhi High Court, Karnataka High Court, Kerala High Court, and National Green Tribunal, various benches, principal benches, clearly stating, even the Supreme Court of India, clearly stating that the ministry is doing wrong, that the ministry is going ahead in violation of the provisions of the powers given under Section 3. The powers under the Section 3 of Environment Protection Act is very clear. It is only for taking measures for the protection of environment. Now, a particular industry is taken away from EIA. That is not that is not a measure under the Environment Protection Act to protect the environment. If you take a particular activity by increasing the threshold, then also this is not a measure for protection. If you are diluting existing provision, then it is against the power given under Section 3. So it is not unknowingly, but knowingly. But after receiving orders after orders or judgments after judgments from the Honorable Supreme Court, that they are doing this to the country and its environment. So I focus on the fact that we should focus our objections. If any person has not sent it till now, we have to focus our objections, even to send a copy to the Prime Minister of India and the President of India, that this ministry has become a facilitation center for environmental degradation. And next is what made the ministry to give such a diluted version. If you see the last 10 or 20 amendments, nobody has raised such a question against the ministry. No official was punished by any of the courts. So they took it for granted that some Thomas or some Matthew or some Harish or some activist from environment group will file a case and they will get an order quashing the order of the government and no further action against the officials. There is no accountability for neither minister nor his officials. So this made them to take things into granted and go forward with the dilutions. So we have to fix liability for officials in the ministry and experts in the ministry. Those who are leading this process to the dilution, they have to be held accountable. Now our next level fight should be that. Third one is with respect to the responsibility of EIA consultants. So many projects have been cleared by the ministry and state environment impact assessment authorities after seeing form and applications. Subsequently, they will come to know that form and applications have been filled with false or misinterpreted data. Once a false data has come into form and application and an environment clearance is granted, according to the Supreme Court judgment, recent judgment of Alembic Pharmaceuticals, the entire process is vitiated because it has come on the false data. So a project proponent and a EIA consultant, if they are filing a false data, each one of them should be prohibited, their accreditation should be cancelled, and the project proponent and the EIA consultant should be blacklisted. Then only there should be an accountable process will come, because Aranmula airport case we have seen, the National Green Tribunal has struck down the EC granted, stating that there was no accreditation for the agency. Now such kind of activities are happening in the field. And my last point, what made this ministry to do this? They think that some persons can come, start industry, pollute the air and water, and go back to their original country or original, they can get away with the violations, and they can divert their whole investment to some other areas. So this is the new model of industrialization in India proposed by the Ministry of Environment. Now, there should be an accountable process of environmental clearance. There should not be a delay from the part of state environment authorities or ministry, because now if I'm an employer, if I'm an industrialist, if I invest something and if I want to start a project, my environment clearance is taking more than 1 year or 2 years. Now this should not be allowed. There should be a clear yes or no within a time stipulated by the law. It may be 6 months. I request each one of you to include in your objection that instead of 105 days, we require at least 6 months for a proper environmental clearance process. This EIA process may take 6 months, but within that 6 months, there should be a final answer, whether yes or no. If that is a no, there ends. If that is a yes, they can go ahead with the project. So speedy a single window clearance process cannot be done for environmental clearance processes. Therefore, our focus should be on this, and most of the other points we have already discussed, I believe, and I am stopping by that.
Thank you so much, Harish sir. We will be accepting any sort of questions or queries now, and Harish sir will answer them. Okay, we have a question here. If EIA 2020 is drafted and enacted, can state governments make required legislation for overcoming the issue?
Not at all. According to the Constitution of India and its latest amendments, environment is it is not only a central subject. There is a say for the state governments. There is a say for the local self-governments. There is a say for the district planning committees, development committees. All these statutory authorities and constitutional authorities are having say on the EIA process and the environment, but they cannot make any law in violation of a statutory notification issued by the central government once it is finalized. They can bring additional laws. For example, if state of Kerala feels that to start a project of, say, more than 1 acre of mining or more than 10,000 square meter of building construction, they have to apply for environmental clearance process. They can say they can have a separate law in addition to what EIA says, but they cannot contradict with the EIA notification.
Okay, there's another question. Please tell me how it affects the right to economical equality, if this is relevant in any form.
I'm not sure about the economic equality, what the questioner thought about, but it directly affects Article 14, right to have a clean air, clean water, and clean environment for all. Not only 21, but also 14. If some portion of this country is getting clean air, and if only because an industry comes in my area without going through EIA process, it affects my fundamental right of equality. Why equality of economical status is mentioned, I'm not sure about it, but economical inequality will be developed if there is no proper scientific redistribution of natural wealth. That is why there is a specific provision in the Constitution. Every natural resource should be equally distributed. There should be equal access. If some person are having more access to river sand or gravel or any of the say land, for instance, then that cannot be treated as an equality. It will create inequality. Definitely, if pollution comes, then if you see the report of Goa mining, Justice Shah Commission report, report says that the entire pollution caused severe damage to the local environment and it affected the local people and their livelihood. But the beneficiary was the mining owner. So it creates an economic inequality.
All right. Before addressing the next question, I think we should go by Sridhar's suggestion that there will be more questions after all of the mentors have spoken. So it would be preferable if all mentors could stay back till the end, if possible, so that they could address everyone's doubts. Yes, so the next question here is, what is the stand of the National Green Tribunal on this?
Question to me?
Yes, question to you, sir.
National Green Tribunal is a statutory tribunal for an appeal against an order passed by the central government. So once this is passed, any person in India can challenge this notification before the National Green Tribunal. But the Supreme Court has said that the National Green Tribunal have no power against a notification, statutory notification. They cannot quash a statutory notification. Now that question is pending before the Honorable Supreme Court. So generally, National Green Tribunals won't comment on a process which is under legal regime. They will take their view only after an appeal is filed, after the process is over.
All right, I think that is the end of the questions for this session for now. Thank you so much, Harish sir, for giving us an insight into the legal aspect of EIA. Now we can move on to Sridhar sir.
Yeah, thank you. I hope all of you can hear me. Shriya, you can hear me, right?
Yes, I can hear you.
No, I'm just testing my camera. See, let me move to gallery 1 second. Yeah, see, because Harish has dealt with the intricacies of the environmental impact assessment draft 2020, and because Dr. Biju also did the same, but brought in a lot of wonderful examples of how this is going to probably impact all of us. I think what I will sort of do, especially because I see that that was not what I actually thought I should do, but it will be interesting to look at the way this whole Environmental Protection Act and the Environmental Impact Assessment came through till now, and the reasons as to why we are having this particular process, and why the sabotaging of the process, the literal sabotaging of the process by the government, is not just going to be detrimental, but it's going to be contrary to the original intention or the intent of the whole process. Now, because all of you who are in this group are also young, I thought I'll use my advantage of a little age to go back to some historical, facts about this, about environmental protection itself. I'll not, take long time. I'll just try and be as crisp as possible. I'll request Riya to cut me off if I go beyond 10-15 minutes. See, the first thing that we have to look at, there is a large history before that also, but I'll start with 1972. And I want, when I'm saying this, it'll be good for all of you to, record these dates. And if you know, it's great. But if you do not know, please record these dates, go back to Google and keep, and 1972, we have what is called the Stockholm Conference. This is called the UN Conference on Human Environment. This is the first time that the world came together and thought that we are really, really, destroying the earth. And in fact, this conference was marked also by a classical speech by our own, Indira Gandhi at that time. And her speech was classical simply because she bought, and this is very important for the current question also, she bought, because earlier it was called, you always had environment, when you say, we always say the problem is development. So development is in conflict with environment, kind of. But she put in this whole question that poverty itself is in conflict with environment. The more the poor people, the more the environment could be damaged. The more the rich people, the more the environment could be damaged. So the whole question of both the extremes of the rich and the extremes of the poor are harmful to the environment. And she highlighted the whole question of poverty itself as among lots of other things. So I would, in my highlights, I would say, please read Indira Gandhi's speech. It's available in some of the law, websites and all that, and otherwise also. So Stockholm Conference, 1972, the Indira Gandhi speech. Now, what did the Stockholm Conference end up with? It ended up with with a thinking that something serious must be collectively done by all nations coming together, and each nation must go back and start working on it. So till that, we didn't have a broad umbrella environmental act to take care. We had certain things which were handling, let's say, dangerous goods or some hazardous materials and all that, but not larger, environmental act. It was the same year, 1972, that we had something extremely interesting come out of the Club of Rome. The Club of Rome is is a federation of ex-prime ministers and ex-heads of governments and some UN people and all that, which brought out this wonderful publication called Limits to Growth. Now, what is this whole limits to growth? It is very clear. It said in simple terms that the way economic activity is happening now, we will not have enough natural resources left in this earth. We are a destructive species. These two happened the same year, 1972. Now, there are other versions, second and third versions of the limits to growth book, which will also be very interesting for all of you to go back to. The 1986 Environmental Protection Act was a fallout or a extension of this process. It took about 14 years, but in between you will see that in 1973 we have the Water Act, in 1981 we have the Air Act, but then in 1986 we brought in the Environmental Protection Act. Now this is actually in line with, or was supposed to be in line with, this whole global process that is happening all over the world. So it is becoming more and more important to understand this, because right now, unlike in 1972 and in 1986, the world is much more threatened now. Our lives are seriously threatened, and we are seeing that happening, whether it be a COVID or whether it be the large levels of disasters that are happening all over the world. Even the most developed nations are reeling under the threat of climate, climate as a crisis. So this is the process that we're talking about. Now we'll go to 1992. That was the time when we had 20 years of the Stockholm Conference. 20 years after the Stockholm Conference, what they did, what is called the Rio Conference. This was in Rio de Janeiro. In Rio Conference, they came up with again a declaration, and post that was the time when the world agreed that we should not wait for the consequences to be seen, but if we perceive that these consequences will happen, we should have precautionary principle. So the precautionary principle got defined in 1992, the understanding of it. And then you will see that in 1993, India is working on the environmental impact assessment, the first of its draft. And in 1994, we brought the environmental impact assessment guidelines. Now, what is this whole EIA? That both of them have already very clearly talked about. The EIA is a very simple process. It's a process where any factory, company, industry, roads, dams, whatever that we could call development at some level of scale, if it is being done in a region, we presume under the precautionary principle that this can have impact on the environment. And hence, you do an impact assessment, which looks at both the positives and the negatives of it, the benefits and the non-benefits or the impacts of it. And then you also develop something called the environmental management plan to see whether this can be alleviated or this can be corrected or this can be avoided. So from there on, you will see that even though the intent of the NEPA or the EIA was right and good and came from global statutes or global conferences, we'll also see that over the time, our industries, our business houses, and even our bureaucrats and governments have been able to sit and see and plug holes in it or create holes in it and ensure that they can use the same process to actually get through the industries, get through doing industries, etc. So the 1993, the 1994 EIA and the 2006 guidelines, the new guidelines of 2006, which I will say that the 2006 guidelines was itself, and as Dr. Biju was also saying, well, it's itself a huge dilution, because the 2006 EIA was hugely influenced by the globalization agenda. Because when globalization, liberalization, and privatization, the LPG was happening, India had to open up. And when India had to open up, all these companies are coming. We are having huge industrialization, a sudden burst in operations, and then it had to be, there were high levels of dilution. Now we will all ask ourselves the question, and all of us here will ask ourselves the question: has this loss, whether it be the EPA or the EIAs of 2006, even 2020, we'll come to 2020, have been effective in handling the environment of India, in terms of environment protection or conservation? Has it been effective? The way the rivers are polluted today, the way our air pollution is happening, the way every single river in India is polluted. Our cities are polluted. Our industrial belts are polluted. The industry is not blowing up every other day, kind of. Every month you're having some accident here or there. the Elur-Edayar industrial belt in Kerala is supposed to be from where Harish comes, Ernakulam, is supposed to be a global toxic hotspot. If the Indian law was adequate, would this have happened? Which means that in spite of the EPA, in spite of the EIA, in spite of all the legal mechanisms, in spite of all the jurisprudence that we have, India has utterly failed, completely failed in creating a safe environment in any of the spaces that we have done. Every single industry in India, and I'm somebody who has walked into, I would say nearly 100 and 150 industries, directly and indirectly. We worked on the whole Elur-Edayar industrial hazardous industrial belt. And we have also explored industries across the country. I'll tell you what, it's a mess. Now, how did this happen? Look at the dam projects, again in a mess. Rehabilitations have not happened. So the inadequacy is stark, is clear. Now, the bigger challenge. 2000, and Dr. Biju pointed this out, 2006, 2020, 14 years. How will you and me mark this 14 years as far as environment is concerned? As something that became better or something that became worse? Obviously, something that became worse. Because it is all these 14, 15 years that we have had such a huge outburst of all sorts of diseases, for example. Coming back to the COVID reference or the SARS and the MERS reference or even the Ebola reference globally. All the disasters are happening in terms of environment. We are having, climate change as a serious concern. We are having huge depletion of natural resources. We are having to create the list of it. Oceans are being dumped massively with plastics and all the kind of waste. All the effluents are going right into the ocean. We have killed fish kills like never before in the last 2 decades. Loss of biodiversity, increasing scale of epidemics, as I was saying. Localized and globalized deforestation. We have actually lost more intact forest than ever. And floods, urban flooding. Can you name any town in India which doesn't flood nowadays? How did it happen in spite of the acts? So we have, Himalayas, look at the Himalayas. The glaciers are all coming down and they are not reforming themselves. The climate change is having an impact. Now, with such a large level of crisis happening, how the hell does this nation or a government or a minister stand up and say that what is important today is to do ease of business? So the problem is that while we see environment or anything on attack on the environment under the EPA as a crime, it happens to be, it comes to, to me, what I understand right now is that the criminals are running the country, are running the environmental ministry. Otherwise, they wouldn't probably be doing this. Let's be very clear about it. Now coming to the next level of it. See, what is the environment ministry supposed to do? You have various ministries. You have industries ministry, you have water ministry, you have human resources ministry, you have the education, all sorts of ministries. And they all have frameworks. They all have their protocols to do. They are supposed to do certain things. What is the environment ministry supposed to do? They're not the ones supposed to be looking at GDP. They're not the ones who are supposed to be looking at environmental, how to allow industries in a very antagonistic environment of people, questioning them. They are supposed to be only looking at the environment. And in all these ages, we have had some periods of that when Jairam Ramesh was there. Obviously, industries also functioned there, but they had to go through such levels of scrutiny. He made the environment ministry at least something that is open, transparent, and dynamic. We also have critiques of him. That is something that environmentalists will keep doing. All the scientists like Dr. Biju, all of us will be doing. But then there's a process that happened. This environment ministry is not functioning as an environment ministry. It is literally functioning as the heavy industries ministry. Why I'm saying heavy industries and industries ministry, or let's say the water resource ministry, or irrigation ones, which are looking at dams and all that. Let me tell you why I'm telling this, because this man called Prakash Javadekar is himself in a conflict of interest. He's sitting on 2 ministries, one for the environment and one for destroying the environment. No, you can't do that. So this whole problem is that at no point of, when you're talking about environment ministry, they're not the ones to look at ease of doing business. They have to look at, things like ease of doing proper agriculture, safe agriculture, or ease of ensuring livelihoods in these communities, or ease of having clean air and clean water. When I go out on the roads, I must have clean air, clean water. Ease of ease of breathing clean air, clean water, or drinking clean water. I mean, isn't that a right? Isn't that something that the ministry should be doing? So now we will come to, because I'm not going into the critique of the EIA, because the critique of the EIA is all over there. I mean, there are 10 different documents that are running around. So my point is this. This particular EIA 2020 is a violation of the basic intent of the original idea of not just the EPA, but beyond. This EIA 2020, and so is the EIA 2006, and this is going to be worse in 2020, will only increase poverty. And addressing that question that somebody asked about economic inequality, it is going to increase poverty because it is going to increase pollution, because it is going to increase diseases and health hazards and all that. It is going to increase poverty. And when you're talking about increasing poverty, the whole intent of the 1972 Stockholm Conference, we addressed poverty there. We are going to end up with more poverty than this under the EIA 2020. So my point is this, that this is what is going to happen. Now look at the other side of it, the whole public consultation and democracy process of it, or the federal system process of it. Till date, we have at least had a process, and this is something that I think Harish also raised, at least had a process where certain components of environmental protection were with the central government, but there was a large component with the state governments. Now they're saying that, no, sorry, the states don't need to decide, we are going to decide. Because all these big companies of Adanis and Ambanis and the Vedantas are coming to us, not to you. And we also understand that some states, like for example, Kerala, maybe in some places or others, are having local issues. We'll do it in Delhi, so you won't have your problem. We'll clear it and send it to you. They've murdered the whole federal system, literally. That's what they've done. In the agriculture sector, which I follow, the same thing has, largely happened. This whole NEIA and the SEIA kind of things. The last thing, before I sort of wind up, maybe the pre-last thing, is who is it benefiting? Who is this 2006 benefited? Who was this 2020 benefited? In the beneficiaries are all these big industries who do not want to behave. They want to pollute because polluting is cheaper for them. Because it makes economic sense to pollute. Economic sense to, the whole Bhopal tragedy was very simple. They wanted to make some money by not operating the safety mechanisms. The safety mechanisms did not fail. It was not used at all. And then blew up and killed 16,000 or 25,000 people nearly till date. Who paid? They didn't pay. They paid paltry. After all this 20 years of fight, they paid paltry. The government is supposed to be taking the burden of it. Now look at all the other industries in the latest 2 industrial blasts that we have had. How does it happen? It's because the industries profit out of it. Does the bureaucrats profit out of it? I'm sure the bureaucrats profit out of it. Otherwise, an environmental bureaucrat shouldn't be talking about ease of business for industries to do. An environmental minister shouldn't be talking about this. And then who else profits? I'll tell you, one of the biggest thugs in this process are the consultants that do EIA. See, I have evaluated a number of EIAs in this country. In fact, we were also part of it, the whole Adirapalli project, EIA. There was some big cement factory that was going to come up in Kodungalur. We could literally stop it. In spite of a dirty EIA, we could stop it. The problem is, and recently I've been looking at some of these EIAs, even one in that near the Technopark region and all that. Terrible EIAs done by terrible, consultants. Now I'll tell you why I'm saying this. See, Vapcos was a consultant which did Adirapalli EIA. Now, when you do an EIA in a region, you go there, you look at all, and there are lots of parameters you have to look at. You're looking at it in detail, and then you are supposed to be saying that these are the facts, and hence the project may not even be viable there. Or you can say that these are the facts, but these can be corrected, these can be managed, but here is a little bigger problem. These are the tribals that are living there. You have to really talk to them whether they want the project or not. So EIA has a whole set of processes to do. And then you put it to the public consultation where public in mass can actually come and say whether they are for it or against it. And if so, why? And then all this is recorded, and the collector or a panel of chaired by the collector gives a report based on which the clearance has to be given. You know what? There was an RTA done to find out whether WAPCOs, which is one of those bigger ones, even now they are there as a big time consultant for many of these places, whether we have asked them, how many EIAs did you do till date? This was in the early, during the Adirapalli thing. And how many were the project rejected or not accepted? I'll tell you, they said 44 or something, I remember. And they said all the projects were cleared. Now that is an impossibility. It just cannot happen. Which means that the whole mechanism itself is a clearing mechanism, is a clearing house system that you have developed. They're only worsening it now, basically saying that ease of doing business. I'll say that this is all about not ease of doing business, but ease of damaging the ecology, ease of polluting each one of us. That's what they're doing. And the consultants are party to it. Most of them, 99% of them. There could be extremely few who would stand up and say that, ye nahi hoga, this is not possible. And you know, the next time they will not be given the consultancy. Because the process itself is that. Somebody, I mean, actually the industry pays and gets a consultant and does it. Obviously, when I, as a consultant, take money from the industry, will I say yes or no? And this is something that we have been questioning in the Environment Ministry, saying that this cannot be paid directly by the industry. This has to be a pool of money sitting in the MOEF. The MOEF have independent people, scrutinize them and say, you do it. Even then I know there will be fraud. So let's not even say that scientists and people, technologies who are doing all these things are holy cows. They have also become dirty, like everybody else in this dirty world. At the end of the day, all this dirt is on us because we are the ones who are getting polluted. So let's understand, all of you, all of us, that, I mean, I completely endorse, and I want, what Harish said in the end. See, this is not a fight for today. People like Harish, people like me have been on this war path. Unfortunately, we don't like to fight. War path for years together. And I'll tell you, all of you young people who are now going to face more of this climate impact, etc., have to do it more and more, unfortunately. Because we are having thugs sitting there, running this ministry. So I think this is largely what I wanted to say. If I missed something, I don't think I've missed something. It's interesting, when Fridays for Future objected to this, they were even going to be charged under UAPA. I mean, talking for the environment becomes terrorism. Anyway, I'm just venting out. I'm sorry, I'm venting out because I thought that, it's a wonderful group of people and we need to talk about it. So thank you for this opportunity.
Thank you so much, Sridhar sir. I think all of us share your concern right now. And I think we can see that with the kind of questions we're getting on the YouTube section right now. So I will list them out one by one. So the first two questions, I'll just club them because they eventually summarize the same thing. Why is media not at all interested in covering this issue? Being the concerned citizens of the nation, what can we do at the moment to cancel the draft? Our voices need to be heard. And the second similar question, a very interesting question, is a person has asked, to change all these things, should I become an IAS officer or start an NGO? Will I be able to raise my voice through an NGO, or if I'm a government employee? So these are like two questions that I've clubbed for you.
First question, straight off. There is always a lot of media people, individuals inside the media, who have always raised this issue. The media house per se may not be, to align to it, but nevertheless they give the space. Sometimes media is also completely, some media houses are completely, on the corporate side, and so what happens is their voices are also, controlled in some sense. Nowadays you are seeing it hugely, because earlier we had media, now we have left media, right media, center media, and so we are lost as to which media do we go to. But there are always good individuals who have fought this fight, who have done this. I think the role of the media is ever more important than, more important than ever nowadays. So we'll have to do. But I will also encourage all of you to seriously look at the other alternate media, the social media, the Twitter media. I see, I was just searching, just before I came, I searched Prakash Javadekar in Twitter, and it's at 960 tweets in the last 1 hour. Terrific. And I went and saw, it's all about EIA. So, which means that we'll have to keep hammering on those media, which they'll probably sit and listen. The Facebooks, the Twitters, the Instagrams, let's all be there. That's one point. They can't See, they can come and catch a Sridhar and say that you're a terrorist, or I mean, even, I don't know. For some of you, I don't look like one, but there are people who can find that this fellow could be a terrorist. Now, my point is this: they cannot go to Instagram and say that you are a terrorist. They won't go to Facebook and say Facebook is a terrorist. So let's use this media to try and do this. The second question, pardon, the second question was about what do you? I'll tell you what. I was neither. I mean, many of us are not per se NGOs or per se IAS officers. We all had opportunities. I was basically an engineer who did a walkout, did some research, did some things, continuously responded. The big challenge is this: equip yourself, skill yourself, learn what is actually happening. Whether you're an IAS officer or you're an NGO or you're an independent person sitting there, I'll tell you there are simple individuals who actually stood up and fought many of these fights, even without being an NGO. While NGOs are conventional methods of doing it, or let's say individuals, IAS officers can go into the government and do it. We know IAS officers who can't or who've never done things, and we know good ones also. So it's not about that. It's about the person. Take your call, but understand that the most critical thing that all of us are facing in the future, from here on or for some time on, is the environment. Seriously, it's the environment.
All right, so just one question before we move ahead with PZ Thomas, sir. There is a huge shift to electric and hybrid transportation, alternative energy, and lots of green projects, but it is saddening to see it is all based on the bottom line of economics. The demand is shifting towards this. That's why how to take economics, environment hand in hand with respect to the EIA 2020, and how will poverty increase through EIA 2020? I think we can wrap it up in 5 minutes.
Yeah, just quickly. See, I think we'll come back to these questions later also, but this one, let me very quickly say that, alternates are great ideas. I completely endorse. As a technologist myself, I'll say alternates are great idea. But let's also understand that we have to have a comparison of how much of these alternates can I use. See, when we were young, we had 2 shirts. Now we have 20 shirts. My child would have more than, kind of. So there is a great study that happened globally, which is comparing the per capita use of resources of, let's say, an American or a Canadian who are the developed world, and then an Indian and other places. And they found that if the whole world, and that is what we are all aspiring, we all want to live like them, because in terms of resource use, in terms of access to material, in terms of driving a car and all that. So they found that based on the total resources that is available in the earth, they found that if everybody in the world will start living at the standards of the Americans or the Canadians, we will need 8 earths. You have 1. You have all the resources within 1. And let's understand that is called limits to growth. That is the trigger to limits. We cannot grow beyond, which means that you work on the alternatives, but also understand that you need to go back to certain level of sustenance, certain level of, reducing your consumption also drastically. And there are nations that are talking about it. The new economics is not just about circular economy. It's also about a classical idea called degrowth. We cannot go on growing like this. We have to do degrowth also. We have to ask the Americans and the Canadians and all those people who are splurging resources to come back and live like normal people. Maybe in that time, then you will understand that some of us, the poorest of the poor in India, or let's say in Africa, is not able to even get what they should probably be really getting. So they will have a little more resources. So this whole balance of resources is something that is needed. Some of us have also been talking about a global convention of lifestyles. We cannot have such lifestyles, as simple as that. So that is the answer to your question of alternatives. Obviously, we'll support alternatives to energy, to transportation, hybrids, great ideas. But eventually, let's not lose the real, thought out there. That's my point.
Thank you so much, Sridhar, sir. I think all of us have this new sense of awareness and concern right now. For all of those questions that have gone unanswered right now, we will address them towards the end of the session where we have a round of questions and answers. Now moving ahead with PZ Thomas, sir. Thank you so much.
Yeah, good evening to all. Am I audible?
Yes, sir, you're audible.
Yeah, that what Dr. Biju, then Advocate Harish Vasudevan, as well as Dr. Sridhar conveyed their best. There is, very few areas which I can address upon. But some certain facts, you understand, because some practical difficulties I'll tell you. See, this government in 2014, they came. Till date, they are very smart in, vocabulary and jugglery of things. They mesmerize people with that words and speeches, and there is totally empty talks. Their mantra is ease of doing business. From 2014, you can repeatedly hear from the top of the country to everybody, same talk of ease of doing business. Now, in the world ranking, if you see between 2014 and 2020, two indices I want to bring it to your notice. For the part of, conducive atmosphere in the country, the world ranking, India is concerned, it has come down from say 120, 25 to less, below 100. Maybe for getting approvals, maybe for land related issues. So these are the different, labor problems, etc., etc. But inversely, Environmental Performance Index, EPI, from the rank of 112 in 2014, it rose to 168 out of 180 countries in the world. So where we are, one way we say we are making a conducive atmosphere for the investors coming into India, but it is other way we are losing. So this is, going totally diametrically opposite direction. This is one part. Now, Dr. Biju, certain, the weakness in the current system. Two aspects I want to add on to supplement what Dr. Biju said. See, overall in this 2006 notification or way back from 1994 notification, there is a basic flaw in the system. The so-called experts selection in the expert appraisal committee in Delhi or the state expert appraisal committee or the state environment impact assessment authority, the selection of experts is a total conspicuous affair happening. Nobody will know who are being selected, how they are being selected, no public notice, no advertisement, no selection committee. This is the basic flow. It is pick and choose. Some bureaucrats, some minister, somebody from the, like people, they keep as the experts in these expert panels who will decide whether the project is to be approved or not. It is not on the consultant. I don't say that consultants are doing a due diligence and not claiming, but fundamentally the decision makers, the expert appraisal committee members, the state expert appraisal committee, state environment, they are the decision makers who are selecting them, whether the best in the country are selected, whether unbiased decisions are taken, not at all happening in the last 26 years. Totally secret manner, this selection is being done. So his master's voice, that member always keeps in the 3-year tenure. Phone call comes, this project is to be approved, this project is to be deferred, this project is to be rejected. Absolutely, he is obliged to the person through whom he is appointed. No other accountability, no accountability to the nation or to the environment. This is the basic flow from 1994 till 2020. In 2020 also, they are not speaking anything on how the procedure for selection of members of expert appraisal committee. Of course, in the EIA notification 2006, there is an appendix 6 which specifies the qualification and experience to be a member of the expert appraisal committee. Yes, it is there. But are you getting out of that qualification and experience? Are you getting the independent, unbiased, the best of the country? Not at all. you are getting a subservient person as a member of a crucial decision-making body. The whole system is flawed. This is number one. Number two, my submission is coming into the 2011 to 2016, the previous UDF government, they appointed some, I am coming from the national level to the state level. 2011-12, the State Environment Impact Assessment Authority, State Expert Appraisal Committee, after a gap of 2006, though it was conceived that state level committees and authorities to be constituted, but first time it was constituted only in 2012. 2006 to 2011, the previous LDF government said, we won't follow a national notification. Unanimously, the assembly passed. I don't know what was the spirit that we won't follow EIA notification in our state. Who advised them also is very surprising. Whether Dr. Sridhar, whether Dr. Biju are aware of these things, there is an assembly resolution by all 140 MLAs that we won't take this EIA notification to our state. They did not constitute the SCIA and SCAC in the last LDF government. Now in 2012, this UDF government came. They selected some people, constituted the first SCIA and SCAC. Now this is the third tenure of the SCIA, SCAC is happening. Most of you don't know. They don't have a proper place to sit. Forget about anything else. What are we talking of the environmental assessment? We all are having some seats or chair to sit. This so-called high profile State Environment Impact Assessment Authority and the State Expert Appraisal Committee, such a enlightened state like Kerala, they don't have the place to sit. Their TADAs are not being properly paid. This is the state of affairs in our own state happening. What we expect from these people, how they will be doing some justice, they are not being even paid or they don't have a proper place to sit after 9 years in this Kerala state. Now coming into the other part of the weakness. See, the post-environment clearance monitoring, it is a subject of serious concern. People take the environment clearance, use it only to the financial institutions for getting their bank loan sanctioned. It is not getting implemented. The statement given by the ministry before the National Green Tribunal principal bench in Delhi, you may not be knowing, I will tell you the statistics. The affidavit submitted by the ministry, 68% of the category A projects are giving the compliance report are being monitored. 92% of the category B projects are not monitored in the country. 92, only 8% is being monitored. Now coming into the monitoring part, you all may not be knowing, I will tell you something within the ministry. There are 8 expert appraisal committees in the ministry for category A projects. 8 coal mining, non-coal mining, infrastructure project, CRZ project, then on industry 1, industry 2, etc., etc. Now, the total scientific and engineering total staff in the impact assessment division, in the so-called custodian of the environment of this country, you know how much is the staff? Less than 10. Single digit, looking after 8 category expert appraisal committees. Now, additionally, you know that how much is the duty of these officers? We should know why it is happening. 40% is the strength of the allotted strength of the ministry, the officers are there. 60% this government is not appointing. Reason, I don't know. Whatever be the glory, this environment aspect has been brought in during the Jairam Ramesh period in 2009-11. This government intentionally want to keep it at the last in the ranking. This is a deliberate attempt which is happening. Now, out of this 40% of the scientific officers in the ministry, they have to look after this EAC, scrutiny of the application, the minutes publishing, conduction of the meeting. Above all, they have to answer RTI questions, they have to look after court cases, they have to attend parliamentary questions. All these things, these 8 or 9 officers have to see. The manpower available is this. Rest of the whole manpower, whatever 2, 3, it is daily wages people. Very frightening picture in the country. This is what, the non-monitoring or the complete, off the track. These are the reasons. Now, there were 8 expert committees, not appraisal committees, constituted between 2006 and 2014. Fortunately, this NDA government has not constituted any expert committee for getting a better advice. They said we are well equipped and well knowledgeable. We don't need any expert opinion. Now, between 2006 and 2014, 8 expert committees at different times suggested various measures for strengthening. They have given recommendation for strengthening of post-environment clearance monitoring mechanism. The EIA draft 2020 does not carry any of the recommendation. They said, we don't want this document at all. We want to simply put it in the dustbin. This is the intent of the government. Forget about the spirit of EP Act. Forget about the spirit of this Environment Protection Act or any other thing. We don't want, simple as it is. I will tell you with another example. There is a document which is all I am talking. Advocate Harish also, we share things. I want to tell you, prior to the election, general election in 2019, and there was a big change. 2019 April, prior to this current draft which you all are having, there was a document called Zero Draft EIA 2019. That was prior to the election. And then the current draft of 2020 March. The draft of the Zero Draft document of the EIA 2019, April 2019, which was fairly in tally or in with the 90% with the EIA 2006. Very minute fine tuning was there. But when they got the second mandate in 2019 May, they went into complete madness. If you see the comparative of the Zero Draft and this current draft, absolutely no comparison. The entire provision. So these all are, democratically elected, we people for the people, which we are doing. The second term when they got it, they thought this is the right time to completely dilute it. Because you can clearly see the difference between the Zero Draft of April 2019 prior to the general election and the current draft of 2020. Now, as Dr. Biju said about solar park, very interestingly, I want to bring it to all of your notice. I have the RTI complete documents leading into this final notification. There was an expert committee under the chairmanship of Dr. S.R. Vote. He was ex-director of NIRI Nagpur. There was a 7-member expert committee constituted in 2018 for the re-engineering of the EIA 2006. Why they said was EIA notification, there are about 4 dozens of notifications amendments, and there are about 225-30 OMs that also make some provision here and there amendments. So let us have a comprehensive notification. That was the objective given to this committee of Dr. S.R. Vote. Dr. S.R. Vote suggested about 10 activities to be brought under the EIA regime, which is not there in EIA 2006. For example, if you compare the 1994 EIA notification and the 2006 notification, certain activities like electroplating industry, automobiles, etc. were deleted, of course, no doubt. But so many other activities were added under the EIA regime in 2006. Similarly, because of the change in scenario, because of the new activities coming up, this expert committee under Dr. S.R. Vatte suggested 10 more new activities to be brought in. One of the activity was solar park. For the information of the all, I want to make it clear. The other activity was slaughterhouses. Then the other was meat processing industries, fish processing industries, poultry farm and poultry kind of industry, cold storages. And recently, about 2 weeks, 1 month ago, there was an article on the poultry waste in Kerala. It is reported daily 1,300 metric ton poultry waste is generated every day in Kerala. So this expert committee suggested with a very detailed scientific reasoning, stating that these activities, solar park, slaughterhouses, poultry, etc., to be brought under EIA. But when the EIA 2020 draft came, none of the activities were brought in. So it is not the scientific community is not giving their input. Government decided that we don't want this dirty document to be seen or to be adopted for any decision making. We don't want this environment to be improved upon. So then what, you people or I can do for this? So this dilution of category A into category B1, which is requiring EIA study and public consultation, were shifted from A or B1 to category B2. No public consultation, no EIA study. Several activities has Advocate Harish had taken out of the regime. The primary purpose for this EIA is to impose restrictions and prohibitions. When this industry is not there at all, what is the prohibition and restriction you are going to make? The very intent is defeated. So wherein we are fighting, it is not on the intent of the, the EPA or the kind of, but the government is determined with a mind that, this EIA notification or the EPA Act is a kind of eyesore to the corporates, is an eyesore to the industry. We don't want this thing to be. They will take it out completely by 2024. The way the indications are there. We will be, only thing is to get the government out only. Otherwise, I am telling you, there is no other way. With this 4 lakh or 40 lakh objections reaching the ministry, they will issue the same notification, which will be the final notification. But only because of some court intervention, there are some delays happening. Otherwise, it would have been over by this time. Now, 2 more submissions I will make it. Then I will conclude my talk. Hope, Shreya, I am not exceeding my time limit.
Yes, so within 2 minutes, we'll start with the Q&A session.
I will.
9 p.m.
I will
Alright.
complete. So the primary objective, this notification, if you see, they say the intent is to issue a comprehensive notification, rationalization of categorization of project, and the third one was strengthening of post-environmental clearance. These are the 3 primary objectives in the preamble of this draft EIA 2020. It is stated, you all must have read. Now, comprehensiveness. Which I told you in the 14 years of journey from 2006 to 2020, they issued about 50 notifications and about 225 OIMs. If you divide the number of working days versus the total count of 225 plus 250, it is coming every 12th or 13th day, there is a change. 12th or 13th day, there is a change. So they thought of issuing a comprehensive. Now this new notification is such a loosely worded document. You all see today, if you go back, they say that we will issue guidelines from time to time. What does it mean? There will be at least 2 dozen notifications and OIMs within 1 month of this final notification. because from time to time means they are keeping that window open for issuing the notification. So the comprehensiveness they claim is lost. Second, they say is a rationalization of projects into category A or B1 or B2. Categorization of projects in 2006 notification was made based on pollution and the potential of the impact potential. These were the two categories. This was the basic shift from 94 to 2006. 94 was primarily on the investment, but in 2006 it is based on pollution load as well as on the impact potential. Now the rationalization they did here is MSME, micro, small, medium enterprises are either taken out of the EIA or brought under B2. What is this MSME? MSME is only on the capital investment. If you have got a slab of 50 lakh micro, 1 crore medium or a 10 crore small, like that, it has nothing to do with any pollution potential or impact potential. Now, if you are taking a retrograde step of 1994 investment base in 2020, what is the rationalization you are making? The categorization which Central Pollution Control Board did based on pollution potential and impact on the human environment as red, orange, green, etc. That the so-called MSME units, basically bulk drugs, basic organic chemicals, synthetic rubbers, these industries are red category industry based on the pollution index of the CPCB categorization. So one way the ministry is saying, no, these are highly polluting, high impact on human environment, but we are putting it into the most lenient category in the EIA regime. So the rationalization theory is gone. Third part they say is post-environment clearance, we are making it more strong. That is the other third objective of this notification. The half-yearly report is going for 1 yearly. The non-compliance to the conditions of EC till date, that if you are taking environmental clearance and if the conditions are not complied, till date, from 1994 till date, it is considered as a violation to Environment Protection Act. But here they say, no, this is not a violation. It is only a non-compliance. My simple question is, if an industry without taking an environmental clearance started the industry, we all said this ex post facto, that is because it will create or it will cause damage to the environment. If somebody takes the prior environmental clearance and not following that conditions, they are also damage to the environment, isn't it? If it is so, then why can't this non-compliance, last 26 they followed, that why can't it be a violation under of the EP Act? So the theory they say that this is for strengthening of post-EC is also wrong. Now, last my submission, as Dr. Advocate Harish said, the National Green Tribunal and the power, whether they have the power to set aside, quash a subordinate legislation and notification. It is a dispute before the apex court. Now, interestingly, all young generation as well as the seniors understand one thing. 2010, this National Green Tribunal Act was brought in by none other than Sri Jairam Ramesh, and the nodal ministry attached to this National Green Tribunal is a Ministry of Environment and Forest. So for all practical purposes, whether it is the administrative expenses or other things, MOF is the people to look after the NGT. So MOF is the looking after agency of NGT. You know something interesting, you will be shocked. Ministry of Environment and Forest, when a public spirited individual or an NGO challenges a notification before the National Green Tribunal, this very ministry come and say, no, you don't have the power to set aside or look into the virus of a notification. It is not private individual or the NGO is going and telling. It is the ministry who is accountable and to defend the NGT, that institution. They come and say to the NGT judges, no, don't look at this notification. You don't have the power. What should I say more? If the protecting nodal ministry says you don't have the power, then who else will establish the power to this institution? So in brief, there is a concerted effort from 2014 till date, whether it is notification, dilution, weakening of the institution called the NGT, non-appointment of the staff or the scientific community staff in the people in the ministry, every nook and corner, wherever possible, lose all nut bolts of this environment. Complete. This is the intent. So the new generation, you people have to take a call whether we can proceed. I am becoming emotional in telling you. It is nothing I am talking on the air, all based on the complete analysis what is happening in the last 6 years. By 2020-24, it will nothing but environment ministry also maybe with some other ministry they may attach. MOEF won't be there at all. It will be with some industry ministry or power ministry as a subordinate ministry. Thank you very much.
Thank you so much, sir. That was very, very insightful. Due to some time constraints, we'll also wrap up the question and answer session real quick. Before proceeding on with that, I would like to ask the other mentors and experts on board if they have anything to add on. All right. Okay, so what a lot of questions comprise of is coming from government employees. And this is a question to the entire panel. So we have a question. If I'm a government teacher, will I be able to protest against government actions through an NGO? And this is a repeated question by many government employees. So what would be your message to them?
Definitely they can raise their voice. This is a statutory right given to every citizen of India. I can say even the Prime Minister of India's secretary can raise his objection against a draft notification. There is no doubt, because the service rules only talks about not to criticize the policy of the particular department that you work. If she is a teacher, she cannot raise voice against a policy of the education department. Now it is not a policy, it is not an act. Government is inviting objections. Please object us. Therefore, even the Prime Minister of India can say objection. There is no rule violation.
All right. There's another question for PZ Thomas, sir. If they withdraw the EIA draft, is it possible to start small industries? And if EIA is not made, there are many chances to bribe to start industries. Anything from the panel?
Yeah, can you repeat the question?
All right. So
no, this will lead to bribery. That is the doubt. EIA process, strengthening of EIA will lead to bribery.
Strengthening of offices.
EIA. Every law in this country is a tool for corruption. Whether the law is there, whether the law is not there, some officers are corrupt. We have to expose them as we expose this ministry. Therefore, the solution for reducing corruption is not to take away the law as such.
Correct.
IPC, Indian Penal Code, is there. By misusing Indian Penal Code, some police officials are asking bribery. Will we get away with IPC? Will we ask for cancelling of Indian Penal Code? No. Therefore, law is something different from the misuse of law.
See, and to also supplement Dr. Sridhar, if you want to start, sir.
No. Just wanted to add to Harish what he said was that, see, and also law is not made for aberrations. It's made for the general. And hence, aberrants which do corruption will always be there. But then the law is a generalized process, which means it's more for the commons. Sir, yourself.
See, for the youngsters, I will make this whole this EIA affair into two small stories. Continuing with the whether are we in an effective manner, we could achieve anything. Still, pollution is there. Still, environmental degradation is there. In some very small, very minimal example, in a house there was a security guard and a CCTV camera. But despite there was a theft took place in that house. There was a security guard, there was a CCTV. But that does not mean that you remove the CCTV and the security guard. You have to strengthen it with another security guard in the rear and the front. But the government is intending to remove the security guard, remove the CCTV. And second example, I'll share with you. See, in some of the talk I share, in a village, in a remote village, there was a train used to go in 1 p.m. every day in a particular same time. There was no railway crossing, no railway gate, and keep this draft EIA or the EIA concept behind your, this thing. And there was no level crossing, there was no security guard, no guard or anything. Then there was no casualty. People took care of the villages, took care of themselves. Then, one day, then started more and more trains. It come in irregular times. Then casualties started. Then the government decided to put a level crossing. That is a so-called restriction we call, imposing of restriction. And it is for the safety of the people there. So there is some time there will be level crossing stop. You cannot have a free movement. So you have to wait. And then once the train goes, so that restriction is primarily meant for the safety. Now one fine day, a rich man coming in that area, he is coming with he was in a hurry. He could not pass through that because of the railway gate was closed. So he called the railway authorities and said, I have to come frequently to this area. I am so connected. I am highly influential. So they remove this gate. So the railway authorities thought, okay, let us have a notice put for the village's opinion, whether this gate is to be removed or to be retained. This is the typical, this EIA draft which is before you. Whether the railway gate is to be removed. First of all, you see the absurdity of the question. Whether can the government put up a notice like this railway gate is to be removed? Because that influential individual is so powerful, he is telling this railway gate for him alone to be removed. Now for the entire country, people, government of India, the custodian is asking, can we take out this activity from EIA? Can we shift from A to B2? Can we take it out of public hearing? This is asking the entire 130 crore people. The government of India is asking. Railway authorities asking the villages, can we take out the gate? So ultimately, government of India through this notification and the final notification which is going to do, we are not concerned about the safety and health of the villagers. I am putting that micro example. We want to look after this rich individual. His thorough movement should not be affected. So this railway gate, the restriction, the guard there to be suspended or to be removed, and the signal or alarm also to be removed. Let fatality happen every day, like in Vizag or in Assam or in any industrial area. Let it happen. We are protected. Our business partners are the corporates. May it be Ambani or Adani or Vedanta. They are our business partners. Not the people of this country are not our, please mind, underline, bold, italics. I say, quote, the current government partners are the corporates of this country, not the citizens of this country. The corporate, what they want, they will prepare the EIA draft, they will prepare the finance bill, they will prepare the labor law, and pass it on to the government. Pass it. This is to be approved. That's all. This is the state of democracy we are. Thank you.
Thank you, sir. I think these were really great analogies in helping us understand how lobbyists influence the democratic system in the present right now. We have another really good question for the panel. Can we do anything at the constituency level since the system seems to be in the center's hands?
At the constituency level.
Yes.
At the assembly constituency or the.
See, I think, yeah.
Yeah. See, basically, see, this is a draft which has been put for public opinion now at this point. I think Harish will also add, and this has not become law right now. So when it becomes law, because I think it's an EIA guideline kind of thing, it will just go into law. Obviously, as parliamentarians, or objections can be raised. I understand that Jairam Ramesh, who is leading the parliamentary committee, is already taking it up and is going to have a discussion on it, which is unprecedented, but I think he is doing that. There is no block actually for any state government to take and discuss this. There's nothing which says that state governments cannot discuss it. State governments can take and discuss it, especially those factors where their federal rights have been questioned or taken away in the new process. So it is possible, but in terms of it's also about this. Some of these legislators who are lawmaking people, they also don't understand that they're lawmaking people. They think that they are people who have to go to the parliament and keep voting. That's all. But they are lawmaking people, which means that they can take all these things, come back to the constituencies and discuss. Nothing stops them from doing it. Some of them are also doing it, is what I understand.
Yeah. Right. Okay, thank you, sir. We have another question for Biju Kumar, sir. Can UN take action against EIA 2020 as it is against sustainable development goals?
Not really, because all the United Nations bodies are basically they have only the advisory role. And since they have an advisory role, we are supposed to make our own legislation and then follow our own legislation. Unfortunately, that cannot happen. You take the example of America stopping money to WHO, and nobody can do anything. And then ultimately, it's basically, as Mr. Thomas said, these are all corporate interests which drive the country. And for the youngsters, those who are really interested in knowing the whole environmental history of India, you should actually go through the literature, not through the the readings in the newspapers, but you go through this history right from Mrs. Gandhi's period, what happened to the environmental legislations, and how systematically this was diluted, and how systematically the corporate interests came into picture after globalization, and how systematically the people's voices were kept aside by a group of bureaucrats and politicians with the support of the corporate lobbies. And these are the things to study. Basically, a deeper research is needed to understand. But unfortunately, somebody asked about the media. There are some good media guys who actually bring it into the notice. Many other things which are hidden are not exposed at all, because the interests are something different. The company is giving advertisement to the news media, and then nobody will actually say anything about or against these kind of violations. But my again doubt to Harish, Advocate Harish, is that what would be the the role of the Green Tribunal in future? If this kind of a thing is happening, and also you look at the number of companies which are operating in India, these kind of polluting industries, without permission, without even a single permission. And then the amount of pollution they make, amount of environmental infringements actually they are making, and this is also something to be studied in detail, isn't it?
With all due respect to National Green Tribunal, being an officer of the tribunal, I will tell you, this is a mockery process. It is a clear statute which can interfere with all these violations. It can have even interference with the local laws. Like if I am violating a local law, panchayat law or municipal law, if it is against the sustainable development, the National Green Tribunal can interfere. But I will tell you, Dr. Biju Kumar and all others, those who are hearing, out of the 30,000 environment clearances being granted in this country, only 1% of these ECs are being challenged within 30 days. You take the appeal number of the Aranmula airport case, it was 273 and 301, 2 appeals. So only 300 appeals are filed altogether in Southern Bench in 1 year, out of which less than 3, that means less than 1% of the total appeals are allowed. Only 2 environment clearances were rejected. So out of 30,000 ECs granted in a year, only 2 environment clearances are rejected. And most of the cases, I will tell you one EC example. I will take only 1 minute. There was an EC granted for river sand mining in Kannur district. The river sand mining, there is a sand audit report. Sand audit report says there is no sand available above the water level. Supreme Court says no mining below the water level. So I said, even according to the report, EC cannot be granted because there is no sand available above the water level. But there is a specific condition in the environment clearance stating that no mining shall be conducted below the water level. But the sand audit report says there is no sand below above the water level. So I asked the Green Tribunal, now how can this EC be granted? Because admittedly there is no sand. They rejected my appeal saying that since there is already a condition to protect your interest, no mining will be conducted below the water level. So EC is allowed to be operated. This is the level of National Green Tribunal. And I will tell you, so many applications on merit have been filed before National Green Tribunal. They are simply sitting on it. They are passing orders only for the fame, some local public newses or national media to take up. So they are interfering only with some big issues in which they want headlines stating that National Green Tribunal is interfering with green matters and to sustain themselves. It is a post-retirement post after all.
Okay. Thank you.
Thank you so much, sir. I think as a final conclusion round and a concluding remark from each of the experts present here, one question would be on how the youth should be acting right now, considering a lot is being done from, be it from movements or organizations like Fridays for Future and other smaller organizations that are local. What should the youth specifically be doing right now? Because one aspect that we are failing in is a lot of youth do not either care or see it as a contextualized or localized thing. They do not relate to EIA, something that is, weighing upon them and going to affect them, as well. So starting from, I think, Biju Kumar, sir, what would be your thoughts and suggestions to the youth?
Though the India's fate is something entirely different, with more than 30% of the population we call it the youngsters, and the government not purposefully making any effort for ecological civilization, creating an ecological civilization. This is very interesting. For example, a country like China, which ruined many parts of the world, they now preach for ecological civilization, and it is actually their manifesto of the Communist Party in China. But still, the environment awareness component of the ministry is shut down and Harish is aware, Sridhar is aware. There is no activity at all for making the people aware of that. And we still believe that everything work with the skill development program, and we have the 4th industrial revolution coming up. So we believe that everything happens digitally. Okay, so this kind of digital mindset, and there is no digital mindset, but actually there are some hormonal issues with these kind of old people who are actually framing policies for us. There is nothing left for the youth. But again, the only way to remain hopeful is to remain hopeful. Okay, but the youngsters actually what they should do when they work with the Internet of Things, almost 90% of their daily life, try to understand what exactly is the basic requirement for life to continue. And unless and until we do that, there is no scope. We cannot scope, for a better future if there is no life support systems. And there are, realizations starting with Greta. There are realization in many parts of the world that this surrounding is very important for us for our own survival and the planetary survival. So this kind of an awareness is happening. And but only thing is that the youth should actually be aware of it and remain in a network. And this kind of networking is happening. That is very optimistic. And even in this forum, Fridays for Future, there are this kind of networking is happening. But this network actually should percolate down and reach everybody. And in that case, no government can actually take a decision against this kind of youth power. And that should actually happen. There are some sparks happening somewhere, and I think that will flare up in future. Thank you.
Thank you so much, Biju sir. Moving on to Harish sir, would you like to add comments?
I will tell you the existing strategies may not function or work in a democracy like India as we are on today. So instead of writing to ministry on a last day of submissions, now this was going on for the last 90 days, but I can see all people are coming forward on the last day because in June 30, 29th also people were in a hurry. So what I'm telling is, we should also write to our corporations. I am purchasing a Samsung mobile phone or a any other LG's AC or a washing machine to my home. I should write to this company stating that you should support the EIA process in India because we think that your company is a genuine company who supports environment. We should, as a consumer, we should start using our consumer rights. Every consumer who spends 10 paise for a company should write to that company, because yesterday I bought something, a mobile phone. I wrote to that company because I am purchasing your article only because on a belief that your company will support the sustainable development of this country. So you should support. As a corporation, you should demand the government of India to have a clear environmental impact process. You should be accountable for our environment. So if now I came to know that more than 9 lakh email objections I've received in the ministry. If 9 lakh people can write to corporations of India, Tata, Ambani, Adani, or any other corporations, they also will be forced to say, I'm not saying that they are willfully they will come forward, but they will be at least 10 people, 10 corporations in India will come and say that for namesake that we also support this campaign for withdrawal of EIA 2020. So, because this government is going to be there for another maybe couple of years as things are going on. So there may not be a political opposition, but as consumers, if we start using our purchasing power, otherwise we should start to boycott, having campaign to boycott these companies who are not supporting our environmental campaigns.
Those were really strong and powerful suggestions, Harish sir. Moving on to Sridhar sir, would you like to add?
Yeah. See, before adding, just one thing, I saw Shiva Balan, raising some concerns on the whole question of why are we saying withdraw it. We'll talk about restrictions rather than withdraw it. I'll tell you, when almost every tenet written in the document is bad, then you will have to ask them to withdraw it. Then we'll also have to talk about just one thing that we probably forgot in our discussion, is this whole principle of non-regression. Now, this is extremely important. It means in simple language, that once a law is made for certain purposes, you cannot have a badder or a worser law, overriding this law. You will have to have improvements on it. So 2006, we have an EIA. Even if we withdraw this 2010, nothing will happen. We'll go back to 2006 and we'll be status quo. And unless there is a better law that comes in place. So the better law has to come. So principle of non-regression is as important as the principle of precautionary principle, and is as important as the doctrine of public trust, where the government is, doing all this in public trust and not, in just the minority corporate trust. That's something very important. Now, as a message, so that is something that Shiva Balan, just an answer to him, saying that that's why we are not talking about restriction, we are talking about withdrawal, because it violates the whole principle of non-regression. Now, coming to the the message kind of thing, see, let me tell you, as I keep telling that we have all reached. I'm not that old as I look. Let me make it a point, because sometimes people grow gray hair much earlier. But my point is that at the end of the day, there is a struggle that we have done for some years. This is all about the Earth and the only planet where life can be. And eventually, even in a country like India with such populations, we can live happy, peaceful, wonderful lives. You don't need to go to America or Switzerland or let's say Sweden or anywhere. We can still have it here. But then we have messed it up. Now the problem is that all these new changes, climate, etc., are messing it up more, or creating worse impact. And the next generation is standing before it. It's like standing before the sea. You're looking at this huge ocean of things, and then you're looking at, my God, what to do. The big challenge is what Dr. Biju Kumar also says. We better start understanding learning beyond the cell phones that we or the social media that we engage with a lot, or our networks that we engage with a lot. A lot of manpower, women power, human power basically is needed on all sectors related to this issue, which means on the science part of it, on the technology part of it, on the response part of it. So when I work with Dr. Biju Kumar, I depend on him for the science of it. Whereas taking it into the the larger question of putting into a debate, etc., we do in some sense. So it means that at some point of time, a lot of you will have to come together to work as a collective and keep helping each other to take this whole concern forward. One sentence, it is now your problem. As simple as that. And please understand that when we were young, or Harish and all of us were young, our problem was much, much simpler and lesser than your problem. And you can look at us for thinking, for solutions. We'll come and take sessions for you, all this. But please understand that there's a serious problem and it's your problem. Thank you.
I'm still young.
Okay.
I mean, I'm not old. We are still around, but yeah.
Thank you, Sridhar sir. I think with great privilege comes great responsibility as well. We have Akhilesh here as well from Bring Back Green, and he has a question for all of you. Akhilesh,
I'm
over to
really
you.
sorry at the end, but I think one important question that we missed was about see how Fridays for Future, Let India Breathe, and a couple of organizations faced problems on raising issues against EIA. They were charged on saying that there was a denial of service attack on emails and things like that. So how do organizations such as us keep out of legal trouble when we are doing activism, or how do we prepare our campaigns or strategies in alliance with not being getting sued?
See, I'll volunteer the answer, and I think Dr. Biju and others can add, because basically I come from from an engineer turned environmentalist turned activist, also a researcher, and we've done publications also. See, it's a mix of all this, Akhilesh. One, you have to be very clear in the science of it. We are not standing up. If somebody, after listening to us, think that we are instigating people, let me tell you, we are standing on tons of documents, tons of experience, tons of science, and saying some things. So that is one fundamental thing we better be very, very clear about. The justifications on which we are going to stand up and say no will at any point stand up. Will stand with us. The second thing is that we also need to have the strategic skills of doing it. I'll give you a little quote. There was this huge Paris conference that is happening, on the climate change. And then in France, then there was a crackdown because all these activists had come there and said, we'll protest and all that. So there was this huge show of about 5,000, 10,000 people who were supposed to be standing on the road in Paris and say, and protest against the climate conference for negotiating a bad deal. And you know what? The French police cracked down, said, no, you cannot stand. You know what these activists did? They went one by one and put the shoes there on the road. And then took this classical photograph of actually people. So the protest was also done. The strategy was interesting, but the message also went globally. So my point is that we'll have to think about interesting, legally right set of strategies. The third thing is where Harish and others play a great role, which is the legal strategies. Because when even in this EIA, at the end of the day, it will have to be challenged legally also. The other crackdowns will happen because sometimes, even what they did, what the Fridays for Future people or lots of other groups did is not illegal. But an illegally thinking government who have things to hide will eventually do these things. We cannot be afraid of it, because we have to stand up and say that you are wrong, we are right, and science and law and the righteousness is with us. So but it's also about following Gandhian principles in some way, because we are not going to bash them up. We are going to say the truth, standing up with all our peace in mind. In absolute peace, in absolute righteousness, we have to stand up and say that. And that is where Gandhi, at the end of the day, he gets beaten up by the police, he'll go and shake his hand and say that, but I'm also struggling for you. So, in our lives, we have had this level of experience. And so these are the things that we also probably have to learn over the time when, when we are facing this kind of questions. Yeah.
Harish sir or anybody else also would like to add on it? Or
No, Akhilesh, this is, for example, you look at the ban which came to the Fridays for Future group or whatever it be, and this is actually a learning point for you. See, this is, for example, if you decide that you are actually the youth is going to stop all the activities right from here, and then nothing is going to happen, and unless and you realize the crux of the issue, and then uh, you look at the things which happened with many of the NGOs. There is no Greenpeace office in India now. That you should understand. It's an international organization. One of the first, one of the first environmental NGOs established globally after the whole kind of environmentalism got started. And then that is not operating in India primarily because they ask certain questions and they put some issues in the public, and then they're not they're allowed to operate in the country. But this will happen. This will happen with any country who is always promoting neoliberal policies and ultimately want only certain companies to flourish in the country, and who always wanted to see that the quality of life is not something important. If you really go by the philosophy of the Hinduism, or if you really go by the philosophy of the Indian culture, and then what should be given priority is actually the way to live happily and consuming lesser resources. That is not at all happening. And you say one thing in one point, and you work in the just opposite way, and that is what happening with the Indian the political systems. And if it is, I don't say that this government is actually the culprit. It happens with all the governments. That is happening even with the leftist government here, because the corporates actually rule, and the connection between the corporates and the bureaucrats are much stronger in the country. So we need to fight. If you realize that the future generation want what is required is better air, better place to live, and better quality of life, and then definitely you have to fight. And this fight, for example, I still remember, for your awareness, probably you may not be aware, when we were young, we means not Harish, Sridhar and we were young, and then the Silent Valley struggle began. And so I still remember Professor M.K. Prasad Mash used to write in the cards which were at 5 paise then, in his own handwriting. He started writing and posting the whole thing, and to all the people, all the youngsters, and then they organized the campaigns against Silent Valley in all the schools. And even till the end, they were not hopeful that this will come to an end, unless this was only the I will say always that it is Mrs. Gandhi's decision to stop this kind of an exercise, because she knows nature, and because that is actually the culture through which she grown up politically. Whatever maybe her strategies, but there was actually an environment actually within her, and that actually promoted. So sometimes you have to work knowing that, and you will not succeed, but you have to work. And for the environment, that kind of a motto is very much essential.
And I also agree with what Biju said about this. Not, when I criticized I just wanted to correct that. When I criticize the central government sort of lavishly today, it is because we are talking about the EIA. But then Yesterday, I was on television criticizing the state government for the mess that they're creating with the huge number of quarries that they have opened up and destroying 3 crore tons of rock taken from 2018-19 just in 1 year from Kerala, destroyed it. So we also have our own sense of people who are so it. And then look at all the Congress, Manmohan Singh's government of 10 years. I mean, they were such an anti-environmental government in some sense. So my point is this, that we have to create this whole feeling and ethos a little more better and strongly, at least for your generation, which now needs to face the music kind of. That's the whole problem.
May I add?
Yes.
Yeah, see, Mr. Akhilesh, see, on 30th June, the Delhi High Court ordered for translation of this EIA draft into 22 vernacular languages. So far, MOEF is adamant, saying that we will not do. On 8th July, Karnataka High Court started saying from 8th July, and the final order was on 5th August. They say you translate it. Till the time, if you don't translate, we are putting the stay on the draft notification. It came to that much confrontation between the executive and the judiciary. So we have to, as everybody suggested, the legal remedy also is partly we have to make the executive under check. We have to fight. On 30th June till date, they are still adamant that we will not. Now they appealed it in the Supreme Court, saying that strike down the High Court order of Delhi and strike down the order of Karnataka. So they are asking us to translate. We will not translate. This is the kind of obstinate government which you are facing. So as the previous question, what the young generation, you can do. See, in some of the European countries and in Australia, etc., see, the environment as a central topic should come into our politics because of this right to clean air, right to clean water, etc. Now, all started from our, the so-called elected representatives bringing some law, something is published, etc. So the youth of this country as a large idea have this, this topic has to come into the mainstream subject as a talk of the town and talk of the Indian political scenario, that enough is enough. The natural resources, the exploitation, or about the air pollution, this has to come into the general central mainstream topic for the politics. Then only a kind of a major structural change can be made. Thank you.
Thank you so much, sir. Would you like to give any concluding remarks before we conclude this entire session? Like as a message for the youth?
Message to the youth is like every day is not a Friday or a dark day. Some good days will come. There were rulers far worse than the current government. So the history, they all become history. So a new blossom and new brightened day will come. So that is the hope by which we all proceed. So till that time, we have to sustain.
It's a hopeful day.
Yeah.
Be hopeful, because me and Mr. Thomas were fighting against a notification 1 year before about another dilution. We tried our level best to get at least 1,000 letters from Kerala, objection letters. Now we are sitting more than 10,000 or more than 1 lakh letters and more than around 10 lakhs letters all over India. So I am very much hopeful. People did not even hear about EIA. People like Tovino Thomas, Parvati, and so many film stars are talking about EIA process now. Now, this is a hopeful generation where we can still be hopeful about them, thinking about them, and we will fight together. Definitely, people's action will have a impact, whoever is in the ruling.
Yeah, what is required is actually continuity. Uh, you should actually should not be discouraged by some of the negative repercussions which always happen when you are in the environment field. And we continue with the hope, and definitely we have a lot of faith in the youth.
Last to conclude what Dr. Biju and Advocate Harish said, see, on 30th June, that was the last date of the, first, the notification sending objection. The kind of, the talk on 30th June and of today, despite government, the mighty force worked maximum to suppress it, but, it bounced back in this last 42 days. So that is a kind of hope, as everybody said. 30th June, it was okay. It's a kind of a very low profile kind of a thing. But from 30th June, whether it was blocking of websites of Friday for Future and other the youth group, or the actions of the government, whatever way they tried to suppress, but they more and more they tried to suppress, it bounced back. So it gives a lot of stamina and boost to fight back, that yes, it cannot be suppressed. It is gaining more momentum and more energy. So that is the thing which I straight away saw between 30th June and 10th August, between this span.
Just one sentence. The UAPA threatening letter was withdrawn within 24 hours. That is the pressure of the public outcry. That letter was withdrawn without even before registering an FIR.
Thank you. Thanks everyone for adding in. This gives us a lot of hope actually to conclude with. The change that you have said, like from June 30th today there is a lot of discussion happening on EIA in Kerala itself. People who were just doing jokes, sketches and things like that on YouTube started bringing the topic up. People are really getting to know about it, and there is a lot of action being done as well in terms of maybe sending the emails or letters, petitions and things like that, and whatever effective ways we could approach. There was a lot of things we got insightful from this discussion. It went way longer than we expected, but still I think everyone got a very fruitful amount of information out of this. Thanks to each and every one of you who has joined. Thanks to Biju sir, Harish sir, Sridhar sir and Thomas sir. Thank you for taking your precious and valuable time and joining with us.
All right, Akhilesh, before we conclude, can we all take a screenshot of all of us? Just a suggestion before we leave.
Yes.
Okay.
So,
all right, okay, I think it's done. Thank you so much to all the viewers as well. Thank you for this amazing expert panel. Good night, everyone. And thank you so much for tuning in again.
Thank you.
Thank you. Thank you, Shreya. Thank you, everybody.
Thank you.